very, very fond of eating. If at all any gentleman, any special chef creates a new recipe which is very tasty, and there's a big rush on that, other competitors start following the same, which had been dissuading the innovation in that particular aspect. That is how it was thought to rather encourage it and not discourage instead. Let us come out with a strategy. Whosoever comes with the for the first time for any new thing, he or she should have a full right on that. That is how said what name should be given. They combine two Greek words, which means polon, alone. The mono means alone, poline means sale, alone sale. And that is how the word monopoly came into being. And IPR concept is also a contributor for English word monopoly into the Oxford Dictionary. That is how it came into being. From there on, various nations, they started IPR concept to encourage human creation by using a human intellect. And then, India has become a member of the Gate in 1948, which in 1994 in Morocco, there was a Marrakesh agreement between the UN member states, wherein they developed an agreement which is called the TRIPS agreement, that is trade-related aspects of intellectual property. And that TRIPS agreement came into being from 1st April 1995, even though it was part of as a annexure in that agreement which was signed in Morocco. Therefrom, the WTO was originated, that World Trade Organization. World Trade Organization, India became a rather signatory to that agreement, which under Article 27 makes it mandatory for all WTO member states that every member state has to respect of IPR of all other member states in the respective territory. And that make it mandatory that all member states of WTO, they had to enact legislation. And TRIPS agreement provides a guidelines for enacting legislation which ensures that intellectual property of one member state is respected in all member states all over the world. Then as I told you, I will take some examples how IPR can be practiced and what is an innovation. IPR Article 8 thus provides freedom to WTO member states to enact legislation protecting human rights, protecting public health and nutrition of the masses at large of that respective jurisdiction. And it also says in any scenario where national interest of paramount importance, intellectual property law should be enacted taking into consideration all those aspects. As I told you, there are various aspects. I will take one example of trademark, of different aspects of copyright on a single product. Let us take an example of a camera. You take camera, it has got a provision for patent, design, trademark, and copyright. When you say design, as Professor Ravindra had said, an earlier speaker had said, whenever you take a photograph of a machine, you do not have a right to have a copyright on that. However, patent do provide a provision for such right that is called a design. If you develop a new machine or any article which has an industrial applicability or which has got a commercial application, then there is a provision that only images, pictures of that specific article can be protected through design. In India, there's a design registration, whereas in US, it is called a design patent, where only images are protected. The difference between copyright and the patent is copyright, as told, is lifelong and 60 years beyond one's death. However, the protection term from a design is only 15 years, not more than 15 years. You see in camera, photograph can be protected as a design. Name, there are various popular names of the brands of the camera in the market. And that brand can be protected through trademark aspects of the copyright. Technology involved in that. That technology can be protected. Different aspects of technology can be protected by multiple patents on each aspect of the technology. Copyright, manual, which is their instructions, everything that is protected by copyright. You see, one product has a provision for protection in all aspects of copyright. Similarly, the CD player, how it looks like to look at image can be protected by design. How music is played on that is protected by copyright. Technology, various technical parts and mechanisms of individual parts and technology, they can be protected by the patents, and name as obvious by copyright. Similarly, different products can be protected by all aspects of the IPR. As you see, I will take how differentiate, what is the difference between patent, design, copyright, and trademark. What is protected under patent, I have already explained to you. And criteria protection is that it has to be new and non-obvious. When you say non-obvious, if at all something you come out by using human intellect, a person skilled in the art should not assume and claim it is obvious. Whatever is known in the public domain about that specific technology, anybody can do it. That's an obvious. Therefore, that aspect on which one wants to get a patent should be non-obvious. Design, as I've told you, how it looks like, ornamental pattern, outer design, and articles of manufacturers. Copyright, it has already been explained to you. Trademark, only name. And the criteria is given at the bottom. In design, originality. In design, new and not published. It should have not, then design should have not been public domain at all. Then how rights are obtained? In patent, one has to write details of that technology in the form of a document, which is called the application document, wherein one has to write in detail how it has to be enabled by a person skilled in the art. Whatever technology you come out with, the new technology, a new invention, your document should be in such a form that it should enable a person skilled in the art to practice it. If somebody says whatever is there is I can't practice it, then patent can be revoked. Therefore, it is very important how you prepare a patent document. And what is protected in that document is claim. Therefore, it's the art drafting a patent application, drafting claims. It is the claims language which provides a scope of the protection to a patent owner. And design, as I have already told you, does not need any elaboration. And similarly on the copyright. Life. What is the life of each aspect of the IPR? Patent, earlier there has been different tenure in different global jurisdictions. However, TRIPS agreement makes it mandatory that there should be uniformity in this. And it has been defined as 20 years from the date of application, not from the date of grant or publication. The day the application is put in the first territory from where it is granted, from there it goes into the other country. From the first entry of the application at the first jurisdiction, 20 years from therefrom. Design, as I told you, total is 15 years. Initially, if granted, is 10 years, but it is extendable, renewable for additional 5 years. Copyright is lifelong, as explained by the earlier speaker, 60 years from the date of the death of the author. Trademark is a common law as long as property used as a mark. Registration is perpetual and renewable every 10 years. Earlier, the concept was that trademark and copyright and patent, and design, all the four had to be registered individually in each country wherever the protection is sought, is required. In patent, as of today, it holds the same practice. However, for copyright and trademark, there had been a Madrid resolution where all the WTO member states they met and they decided that we should have a common centralized registration of the copyright and trademark, which should be protected in all the WTO member states. That is done through WIPO, that is World Intellectual Property Organization, WIPO, which is a part of the World Trade Organization based in Geneva. Therefore, one application, if you want to wish, you can put in the individual country, or if you go through Madrid Treaty, then in India itself, you can find the application through WIPO, where you can get it protected in the jurisdictions of your interest. Accordingly, fees, etc., has to be paid, and application has to be made accordingly. As I've already explained the term, what is it is, what can be patented. I will take a simple example. As you know, in Kerala, if somebody has got a ankle ache, he has got a pain in his ankle, and he finds out walking on a specific grass, bare feet, one gets relieved of that pain. Is a new thing. It has been found for the first time by an individual who walks on the grass. Does it mean one can get a patent on that grass? Answer is no, because grass is a natural product. It's not a creation of human intellect. However, if one finds the use of grass for treating ache, on that one can try depending upon how one puts across his or her case in the form of patent application, which should meet the requirements of patentability requirements, which I will say later. There are another example is turmeric. You know, Haldi, which is considered as an antibiotic and is used in standard cooking in almost every household in India. It has a curcumin as a chemical which is responsible and is considered antioxidant, and it is being considered useful for Parkinson's diseases. It has got a biological activities like anti-inflammatory, anti-human immunodeficiency virus, and various. Can one get a patent on Haldi as a product? Answer is no, because it's a natural creation. Haldi is a product which is not a human creation. However, if somebody finds a new use of Haldi, I will come later, new use of a known product is also not patentable in India. But all depends, because they consider it is inherently, this new property is inherently existing in that known product, which is already in public domain and being used. However, there are ways and means how the case is put across to the patent office and how it is prosecuted. And one can, there is a possibility of getting a patent on use of Haldi for a specific new use. This, as I've told you, grass as product is not patentable. And pharmaceutical activities of grass, question mark, how you put it across. Now, I would come across what are the prime requirements of patentability. There are the three prime requirements. One is it must have industrial applicability. It must be a product or process which can be used in industry for commercial application. And second is it must be novel. It should not be there in public domain, either in the form of a physical product in physical form or document form in written form. And third is it must be inventive. To create that product or a process or a design, there must be involvement of a human intellect. That human intellect involvement is called inventive step. An inventive step is very subjective. As I told you, it must be non-obvious to a person skilled in the art. Whenever one gets a patent and that patent is published and put in public domain and it is accessible to everyone, to competitors. Against that disclosure to the public by an innovation by an innovator, one gets a protection right for 20 years, as it provides a base for further invention, further growth in technology in that specific technology aspect. As I told you, TRIPS agreement under Article 27 makes it mandatory that every member state has to respect the IP of their respective fellow members into their jurisdiction. At the same time, Article 8 also says that there should not be a monopoly. There should not be something which kills the competition and which bars all other parties, companies, competitors to work in that specific technology domain which is protected under patent law. To circumvent those abuses, Article 8 provides a provision to member states that they must enact legislation taking into consideration these aspects, which does not allow abuse of patent law by a innovator companies. For that reason, as it was signed in 1st January 1994, it was made mandatory within 10 years from therefrom, every developing country has to enact legislation complying with TRIPS agreement. Underdeveloped countries like many African countries, they had a timeline of 15 years from 1st January 1995. Taking that into consideration, India had to enact legislations, making sure that it complies with all aspects of TRIPS agreement by 1st Jan 2005. In India, prior to that, there was a Section 5. Section 5 was particularly pertaining to the pharma sector. As you know, India is the biggest generic manufacturer in the world. Section 5 did not permit a patent, a claim on drug molecule as a product. It permitted only process for making a drug molecule in India, not the product. To comply with Article 27 of the TRIPS agreement, in India had to amend their patent law, wherein they removed the Section 5 and permitted that the product claims of a drug molecule can also be patented. And that amended act is known as Indian Patent Act 1970. Section 2 provides whatever is patentable under Indian Patent Act 1970. It gives a different criteria. And Section 3 does include all those which is not patentable under Indian Patent Act 1970. As you know, there is a provision and practice by the innovator companies to bar the competitors to come into their respective technical field and have a evergreening of the technology of a product in the respective jurisdictions. For example, if a new drug molecule for which the patent has been obtained and has been granted, its validity is for 20 years. A drug molecule chemical has a provision to exist in multiple chemical forms and multiple physical forms. When I say chemical form, if at all it has got an acid or base group, it can exist as different salts, inorganic and organic salts. In physical form, it can exist in multiple crystalline forms, polymorphic forms. There is a standard practice that if a patent is there for a drug molecule which can exist in salt form, After 15 years of the patent term has been used, 16th year, 16th year, they file another patent for the new salt form. It means it gets an extension for another 15 years. 20 plus 15 come 35 years. Then maybe another 10 years, they get another patent for a new polymorphic form which does not exist. Another line. Likewise, there is a provision, a patent drug molecule. Patent for a drug molecule, one get a protection up to 70, 80 years. This practice deprives the public at large accessibility to a generic form of a drug molecule which is protected under patent, and the price for the patented product is enormously high. For that reason, India has provided a provision under Section 3, wherein it says, Section 3 I will come, where it says, any physical or chemical form of a known product cannot be patented unless it is supported by enhanced efficacy. That bars patentability of any other physical or chemical form of a known product under Section 3 in India. There has been many cases which went up to Supreme Court in India, wherein the patents were denied. For example, there has been a case of Novartis drug molecule in India, with patent for its salt was denied, and it went up to Supreme Court. And Supreme Court said that, for example, Mercedes car, it has got the capacity to be run at 150 miles per hour. However, Indian law says that this car should not be driven on Indian roads for more than 80 miles per hour. So, though it has got a capacity, but it has to follow the local jurisdiction laws. Similarly, for patentability, local jurisdiction laws has to be taken into consideration while granting a patent. As it does not meet 3D requirements, therefore, it is not patentable in India. Secondly, methods for agriculture or horticulture. Section 3D also does not allow patent on these aspects in India. Fourthly, plants and animals in whole or part thereof, other than microorganism, but including seeds, varieties and species, and essentially biological properties of production, propagation, etc., they're also not patentable in India. As they say, it will rather bar and discourage experts in agricultural field, which is one of the very prime activity in Indian jurisdiction. Similarly, it has been explained that computer program per se, as the earlier speaker had in a very vivid manner illustrated, that computer program as such are patentable under copyright in India, not under patent. However, Section 3K, which bars the patentability of softwares in India, say per se. Per se means if at all a software for which meets the requirements of novelty and inventiveness and non-obviousness can be integrated with the machine in an industry, then it is patentable as a patent in India, not per se. Not if at all it is only in this mathematical algorithm form. That is not patentable in India. Then Section 3J. When I say agriculture, plants, species, seeds, etc., it was a highlighted microorganism. Excluding microorganism per se from patent protection would be violative of TRIPS agreement. That is how they say, agreement says that microorganism which does involve engineering aspects should be patentable. That is, say, it permits patenting a microorganism and is in accordance with the obligation imposed by TRIPS. Then energy-related inventions, they are not patentable under Section 4. When it says no patent shall be granted in respect of an invention relating to atomic energy, falling within the subsection 4. Because of this safety aspects, energy-related patents are not patentable in India. 3D, I have already explained to you in detail. At the same time, as I explained to you, that India has enacted legislation and Article 31 of the TRIPS agreement says, if at all there is something which is in the national health and emergency of a local jurisdiction of a member state, then it provides a provision of compulsory licensing. As it was explained by earlier speaker, also I raised this question. It says, whenever patent has been granted to an innovator company in India, it must be practiced. There is a provision, IP strategy by any company, that they have to submit to the patent office under Form 27 about the use of patented technology for the production and revenues generated out of that product which is made using that technology, whether it's a process or product. Because when you talk of patent, there are 4 aspects of the patent on which one gets claim. One is a product, second is a process for making a product, and third is a composition matter. And fourth is a method of treatment which is not patentable in India. When I say product, NCE means new chemical entity. It is allowed. NM is new molecule entity of a NCE, which I explained to you under 3D is not patentable. When I say, if at all, for example, a drug is being made in India by a multinational company, and it is mandatory, once a patent is granted, it has to be practiced and Form 27 has to be submitted every year. There is a provision under Section 84 which ensures that patent must be practiced. And under Section 85, there's a provision, if at all it is not being practiced, it is not being used by industry in India, then its competitor who are barred from using the technology in India, they can approach the Indian Patent Office for compulsory licensing. And Article 31 of the TRIPS agreement provides an authority and provision to the member states that if at all there is such a scenario that in the interest of the public health and there's an emergency and that a particular drug in particular particular quantity of drug is required in that jurisdiction, or it should be available to masses at large at a affordable price. If at all, though the Article 27 mentioned that even if a patented drug is being imported in the country and meeting the requirement, it should be protected. However, if at all there is an emergency and drug is not being made by the innovator company in India and is not available to masses at large, depending upon what the requirement vis-a-vis what is the quantity available and price, then Section 85, complying the Article 31 of this Patent Office, paragraph F, which says, then Indian Patent Office can issue a compulsory license to a party to make that product, and the royalty and the compensation is decided by the Indian Patent Office, not the patent owner. However, this can be done only after the compulsory licensing seeker has already approached and discussed in detail and tried all his efforts all out to get a voluntary license against a agreed terms from the innovator company. If he fails to get a voluntary license, then under Section 85, he can apply for the compulsory license, which is normally given. There has been a landmark case of compulsory license in India with Bayer and this Natco, wherein the drug which was there for the cancer, kidney cancer, it was available in India. It was being made by Bayer in India also, but it was available at a price which equated to 2.3 lakhs dosage per month. It's a very high price. And Natco has tried all out efforts asking them to give a compulsory license, but Bayer refused. And the matter was taken to the Indian Patent Office for compulsory licensing under Section 85, which was granted, can you imagine, at 5% royalty. Bayer went into IPAB, Intellectual Property Appellate Board, which increased to 6%. Then the matter went to Supreme Court. Supreme Court also upheld the decision of the Indian Patent Office, saying against the price of 2.3 lakhs per month, Natco is providing the same product to the masses at large at rupees 600 rupees per month. Look at the difference. And Bayer said, we provide a provision, if at all somebody buys for 1 month, we'll give 3 months medicines free. That also turns out to be very high, and compulsory licensing was given to Natco, and Supreme Court only increased the royalty to 7%. If the buyer had agreed for voluntary license, maybe they would have got 15%, and likewise. That has been the only single case of compulsory license in India. And that provision protects and bars the abuse of patent rights in India. At the same time, earlier the Article 31, paragraph F, made it mandatory that this compulsory license product should be only for domestic use, not for commercial use for exporting the drug to other countries. Then there's a provision that many underdeveloped countries, they neither have expertise nor infrastructure to make that drug. So therefore, even though compulsory licensing provision is there, even if they get a compulsory license, they can't make it. In that case, in Paris Convention, paragraph F, this paragraph F was made permanent, where it says that it can be made for export to those countries who do not have any facilities nor expertise to make this product. That is how compulsory licensing helped, and India enacted legislation complying with TRIPS agreement, but taking national interest into consideration. Now we come to this aspect, how this company should evolve their IP strategies to make maximum use of this patent technology. First of all, as during earlier talk, it was stated that supposing Dr. Shrikant does an invention, he publishes a paper on that invention. That publication does not bar competitors to copy it. It rather provides them a ready-made technology to be used in their industry, free of cost. Please note, though Dr. Shrikant's paper is in public domain and has created a prior art for all others, but Indian patent law does provide a provision within 12 months of the date of filing the publication, he still has a right to file a patent with the Indian Patent Office. And that right is only to the same authors as the inventors of the patent. No other person can ever get a patent on that technology which has in public domain in the form of a paper in a journal. When you have got a patent, industry must take patent, particularly academic institution who have got a great expertise, real, I would say, human brain, who has the capability of creating wonders. I tell you, if you look at the many patents of the original drug molecules, look at a list of innovators, you will find in majority of the papers, Indian scientists as innovators, as one of the innovators of the drug molecule. But unfortunately, there has not been a single, I would say, new chemical entity from Indian market, from Indian pharma company. That's really sad. And they have to look at it, how they can infuse more, rather budget more money into R&D to take care of this aspect. I will give one simple example. There might be many chemists among the audience. Have you heard of a CBS catalyst, which is a catalyst worldwide being used in every laboratory for stereospecific oxidation of an alcohol or RA and imide? You know, CBS stands for Kore, Nobel laureate, B, Raman Bakshi, an Indian scientist, and S is a Japanese scientist. That kind of human intellect Indians have. And Raman Bakshi have studied right up to his doctorate in India. Only for his postdoctorate he went to US. That kind of intellect does exist, but is not being properly used. And let me tell you, if you look at many technologies which big multinational companies are using, they originate from the academic institutions of the USA. For example, I have got a list which I do not have ready with me at the moment, wherein, can you imagine, patent of a drug molecule was sold by University of Wisconsin to Pfizer company plus for $4.1 billion. Look at the price. Similarly, most of the universities in the USA, they are having the revenues, major revenues, out of the out-licensing of the technologies in the form of patents to the industry, which is much more than whatever aid they are getting from the federal government of the USA. And that revenues provides a big, rather, base for creating a lot of employment for the educated sector, for the scientists, and also creating more and more infrastructure for the R&D activities in the industry. You look patent as a product for which there is a buyer. Not only patent certificate as a credential, as a recognition of your expertise, of your intellect. You must take up institutions, in particular I'm referring to, Dr. Shrikant. They must look at on what they should work on, what kind of project they should undertake for R&D to create new technologies in close collaboration with the industry in that specific technology domain, wherein there is a big scope of getting a lot of revenue for your R&D efforts. At the same time, patent created out of the technology which has been generated, for which there is a ready buyer to take it, as it can add value to the business, to the user, potential user of the technology. And that out-licensing is a big source of revenue for academic institutions to create more and more and better infrastructure for R&D, and also providing great opportunities for scientists and employment in that sector. Therefore, it is of paramount importance. For instance, many national laboratories in India, which have got funds worth hundreds of crores, maybe thousands of crores, like CSIR, look at the major patent portfolio they have got. Because getting a patent, it costs money. Not only getting, but maintaining a patent to its fullest term costs maintenance, which is a huge money. Vis-a-vis, what money has been spent for creating that patent portfolio and the revenue generated out of that. That will rather speak of the facts that whenever one takes any R&D project, one must look at all aspects in respect of its use in the industry, and ready buyer for that. And it gives a lot of encouragement also. These are the various examples which are there for the outlet sensing. Now, when I say this is a very, very important factor which one has to take into consideration. When I say infringement, once you got a patent, many industries, how they have to evolve their IP strategy is when you take up an R&D project, there is a aspect which is called technology landscape. One must know what is already known in that technology domain, because that technology landscape will provide you white spaces, to identify white spaces on which one can prepare plans for the new projects, and also identify shortcomings in that technology which can be used in the industry by overcoming those shortcomings. It is important that technology landscape must be created. Due diligence of the landscape is very, very important. Based on that, new projects should be evolved and undertaken in close collaboration with the industry, and patent should be taken over. And more, that technology landscape also provides you ready technology, because when you say patent, it's a very bad concept. When you see a patent has been published, any document which is published is not enforceable. Moment you put an application, it gets published within 18 months in India per se. However, there's a provision by submitting Form 9, one can get it published within 1 month. That published document is not enforceable at all unless it is granted. And percentage of the application and grant is less, is not big percentage. And many patents, though in public domain, might have completed their term. Or many patents, though granted, have not completed their term. Though from the date of publication you see that it is still valid, but might have not been maintained by paying the maintenance fee, therefore expired legally. Therefore, technology landscape provides you many ready technologies to the researchers, who in turn can start at a higher end of at higher stage of their R&D rather than starting from the scratch. Because some of the information of advanced stage may already be available at free of cost, as it is not enforceable. Therefore, due diligence of landscape is of paramount importance for an industry as part of their IP strategy. Secondly, when industry gets a patent, they are using it for their business. But as you know, patent has got a jurisdiction-wise protection. It's not if you get a patent, it is protected all over the world. You have to file a patent to various other countries where you have got the business interest. And data filing prima facie is from the 12 months of the date of publication, the date of application of the first patent application. However, TRIPS agreement provides provision through PCT, that Patent Cooperation Treaty in Paris, that within 12 months, if a PCT application is submitted, then the window for filing in any other country become 30 months. Many applications you might be seeing WO, which is a word application. Please note, those WO applications are not enforceable at all. They're only in application stage. They're never ever granted. It is only a medium through which you can get your technology's status ascertained through international search report, which is examined, and also widen the window of filing in other national jurisdiction from 12 months to 30 months. And 12 months to 30 months. Therefore, industry must take into consideration whatever patent they have obtained in India and is being used. They feel that since they do not have any business interest in other jurisdiction, Therefore, they should not file a patent in other jurisdiction. Please note there is a provision of licensing, which one can consider, which industry can consider as another business vertical of their patents, of their IP. They have to ascertain that this technology or this product for which industry has got a patent, that may be of interest to their competitors in other countries. They have to identify those jurisdictions and file a patent application of those jurisdictions also. And after having undergone full prosecution, getting the patent granted, making enforceable in those jurisdictions, then approach their competitor where this can add value to the business for out licensing, giving exclusive rights to the or non-exclusive rights, one-time payment or royalty. This is another very big source of revenue for an industry who has got advanced R&D center and have got a great interest in IP. This aspect should also be rather part of the IP strategy of any industry. And third and foremost, one has to look at it. If at all their patent is being infringed, or how the patent has been drafted and how the claims have been drafted, so that strategy should be there should not be any chance to get the patent revoked by their competitor by identifying some flaws. Those flaws may be scope of the claim in the patent, which may be narrow. Second is enablement. Whatever you do, it should enable a person skilled in the art to practice it. Then they should identify their competitor's product. If the patent is a process patent, then they should identify whether this process is being practiced by their competitor. Patent law permits, if you have got any doubt, you can take an injunction and get their manufacturing process legally examined, surveyed to ascertain if at all it is being infringed. And the liabilities are big high. In US, there's a provision. Infringement is a willful infringement. When I say willful infringement means public information, your patent is already in public domain and public knows that it is there and it is being protected. Claims have been well defined. Despite knowing that if somebody's practiced, it is a willful infringement. In such a case, whatever losses patent owners have incurred as the same product based on that technology has been used by your competitor and deprived you of the profits, deprived you of the revenues pertaining to whatever quantity your competitor sold, 3 times of those losses is a compensation which a infringer has to give. In India, this law is not very clear as yet, as of now. There have been many case studies wherein there has not been any compensation in public domain. The compensation detail, maybe there might be an agreement between the patent owner and the infringer, which has not been put in the public domain. So this is how the patent strategy should be evolved by any industry, any industrial sector in India for making their business robust, both in respect of IP and other aspects. At the same time, I would rather emphasize on the fact that academic institutions and colleges and research center, they must make IP as one of the source of revenue generation for their research, and which in turn can give them an opportunity to create a better infrastructure, better resources, both in terms of materials and manpower for doing better research and creating a better IP. Thank you very much. If there is any question, please feel free to contact. This is a topic which one can carry on speaking unabated for hours and hours together. But still, I wanted to rather restrict within my timeline allotted to me 1 hour. And I would also like to emphasize on one aspect. There is a provision for provisional filing. If you are doing a research and it's a fantastic idea and you fear that it may be copied by any person, by any of your competitor, then you can file a provisional application wherein you do not have to write claims. You only have to write whatever publication you write, giving details of the technology and also including whatever you plan doing more work, but you have not done it, but you foresee those kind of inputs also has to be still done and put in this application. And then within 12 months, then you get a right on the priority. Then nobody else can file a patent application on the same subject matter as your provisional application provides you, gives you a right for priority on that specific subject matter invention. Then within 12 months, you have to submit the complete specification filing. And there is another unity of invention also is very important factor. What does it say? You may think that whatever research you have done, it comprises of multiple inventive features. Patent laws say there has to be one patent only for a single invention. Multiple invention cannot be included in a single patent application, which is, as you say, there is the claims. And one claim is the independent claims, which rather relate to a main inventive feature. Other independent claim has to be on the same subject matter, not on the different subject matter. But different subject matter, if at all you think that those not same but similar, but if at all is objected that you want to have a right on that also, then you can put a divisional application, another application with the same priority date, but getting a claim on the other aspects of the similar invention. All the provisions are there by which you can get a protection on your inventions. Thank you.
Participants, you can ask question. I think there is no question, sir.
So it means either it has not been understood or it has been understood in totality. What should be perceived, I don't know.
Anyone have queries, please ask.
You can share my email ID with all the audience. If at all they have got any query, they are free to write to me. It will be my pleasure and to respond to them to clarify on any aspects of the IP.
Okay, sir. Sure, sir. Hello. Thank you, sir. It was a delightful to hear such a detailed and informative session. First and foremost, I thank our today's eminent speaker, Dr. C.K. Sehgal, sir, Managing Partner, Sehgal IPR Services, who, despite from his busy schedule, has found time to grace this occasion for giving us valuable information on topic innovation and IPR strategies. On behalf of SPC Mumbai and HSGB CUT Bhusawal, I would like to convey my sincere thanks and appreciation to you for imparting us your excellent knowledge and for providing technical skills to our participants through this faculty development program. I'm fortunate to have your professional expertise and credential volunteer time from your busy schedule to address our listeners and so as inspiring and expert faculty, and also would like to acknowledge our gratitude to you for exposing your expertise knowledge. I'm obliged to you for your true help, sir. Your session was really lavishing. The session was termed a grand success due to your earnest involvement. I hope you will contribute in the same manner in the days to come for such activity. And thank you once again for sparing your precious time. Thank you, sir. A heartfelt gratitude to our prestigious speaker and great appreciation to our beloved participants for being us positively throughout the session. Dear participant, I would like to inform you that today's second session is over now, and tomorrow's first session will start at 10:30 a.m. with more enthusiasm. Link for the session will share on WhatsApp group. Join the session 10 minutes before. Tomorrow's morning session will be taken by Dr. Santosh Rane, sir. Thank you. Thank you very much, sir.
Thank you very much indeed. Thank you very much for the patient hearing.
Thank you.
Thank you.
Thank you.
Thank you.